Hello everyone, this is Bill Myers and I'm a lawyer in Philadelphia and I'm here in my office with my investigators Dominic Eitri and Mike Kelly. Over the years representing injured railroad workers, I've been asked by union leaders to come to local meetings and explain what the FELA is. I thought it would be helpful to create a video that local union leaders could post on the local union website and members could use to download from my website. So what I'm going to do today is just take a few minutes and talk about the FELA and explain what it is. Let me turn first to Mike Kelly.
Bill, can you please explain to the members the difference between the FELA and workers' comp?
That's a good question to start off with because it's important for railroaders to understand. The FELA is not State Workers' Compensation Act law. FELA stands for Federal Employers' Liability Act. It's a federal statute that applies to all interstate railroads. Under this law, railroads are liable if their negligence plays any part, however small, in causing injury or death to a railroader. Negligence on a railroad's part is the failure to take all reasonable steps to make the workplace safe. What is railroad negligence? Railroad negligence can mean any number of things. For example, defective equipment. The railroad's failure to provide equipment that you need to do your job safely. Lack of training. Bad decisions by supervision or management that place employees in situations that endanger them when they didn't have to. The lack of manpower, the negligence of a coworker. All of these things and others constitute railroad negligence for which a railroad would be liable.
Is there a difference in what a railroader can be compensated for under the FELA and what workers' compensation laws allow for?
Yes, Dom, and this is a huge difference between the FELA and state worker comp laws. Under the FELA, a railroader is entitled to full and fair compensation for all injuries. That includes physical injuries, emotional injuries, disfigurement, scarring, diminished quality of life, interference with the railroader's relationship with his or her spouse. It includes past lost wages and it includes future lost wages. Let me give you an example. In Pennsylvania, if an employee who's not covered by FELA loses a leg, he's entitled to 2/3 of his wages for a period of 410 weeks, which means that if he's earning $1,000 a week, he'll end up with about $275,000. In the FELA, we took a case to trial for a man who lost his leg, and we got him a verdict of $21 million.
Bill, what should a railroader do if he or she is injured on the job?
Well, I'm glad you asked that. There are some important things to do and some important things not to do. The most important thing to do first is report the accident. Report it right away. Don't assume that you can walk it off, and if it doesn't go away, you can tell the railroad about it the next day or the next week. If you do that, if you report an accident late, the railroad can charge you with rules violations, and that's not good for you. The second thing is be very careful on your injury report. The railroad will give you an injury report to describe how the accident happened. And it's important that if your injury was caused by the negligence of somebody else, whether it's management, supervision, or a coworker, you have to spell the details of that out in the injury report because that becomes a key part of the evidence that will be gathered in the case. The next thing to do is inform your local union representative. Your rep is entitled to know, and he needs to know to protect the membership if there's a safety issue that's out on the railroad that other members might be exposed to. Next, you get to see a doctor of your choice. Immediately after your accident, The railroad can take you to a hospital of its choice, but after that, it's your decision who you obtain your medical treatment from. And I always advise railroaders, get a doctor that you feel comfortable with, who you believe is acting in your best interests, not in the interests of the railroad or its claims department. Next, here's something not to do. Do not give a tape-recorded statement. I tell this to railroaders all the time. The claims department will try after an accident to get you to give a tape-recorded statement. The claims representatives are experienced questioners, and through their questions, and I have seen this done, they try to guide a railroad into answers that incriminate him and excuse the railroad. A tape-recorded statement doesn't help you, and it doesn't get to the truth of the case. Apply for Railroad Retirement Board benefits and supplemental sickness benefits. The supplemental sickness benefits have to be applied for within 10 days of the accident, or you could lose them. Finally, at all costs, avoid social media. Social media only hurts cases, it doesn't help cases. I always advise railroaders, if you're seriously injured on the railroad, do not post and do not allow your family to post on social media about your accident, your injuries, or even your quality of life in general.
What's the lawyer's role in an FELA case?
Because FELA is not state workers' comp, but is a regular civil tort case, the lawyer does for an FELA plaintiff everything that a lawyer does for any plaintiff in any civil case, as well as some special things just for railroaders. For example, for railroaders, we protect you from the claims department. We notify the railroad that we represent you, and the claims agent is then not allowed to contact you or harass you. The claims department has to channel all conversations and communications through us. We also protect you from medical interference. And I can't tell you how many times over the last 30 years I've had clients whose doctors have prescribed certain medical treatments, and the railroad, either the claims department or the medical department, tries to talk the doctor out of it or refuse to pay insurance to cover the procedure. We protect you against that and make sure that what your doctor says you need for treatment, you get for treatment. The next thing we do is we will help you with the railroad retirement benefits and with the supplemental benefits. With respect to the claim itself, we gather information. We interview all the witnesses. We gather your medical records. If necessary, we will obtain expert witnesses. And then the case will take one of two directions. It'll either settle or it will go into full-blown litigation. If it goes into full-blown litigation, we will file a complaint, we'll engage in the discovery process. And that means we'll get all the company records. We will defend you at your deposition. We will take depositions of management, of supervision, and of eyewitnesses. And if we haven't gotten experts until that time and they're needed, we will get experts. We'll also get reports and, if necessary, depositions from your treating doctors. And at that point, we will still try to settle the case. But if the railroad refuses to settle the case or they just offer an amount that's not fair, then we'll go to trial.
Can a member be fired for bringing a claim under the FELA?
No, and that's a really good question. A lot of the younger employees on the railroad are fearful that if they're injured and they file a claim, the railroad can fire them. The railroad cannot do that. There is a federal whistleblower statute that prevents the railroad from retaliating against an employee who files an injury claim. That same statute protects coworkers who have information about an injury and want to cooperate with us and give statements about the injury. The railroad is not allowed to retaliate against them either. On that point, the law firm has two handbooks. We have the FELA handbook and we also have the Whistleblower Handbook. The FELA Handbook gets into a little more detail what I've talked about today. The Whistleblower Handbook spells out your rights under the federal whistleblower statute. If you have more questions, please feel free to go to the website or to call the office. Thank you all.